affidavit that kind of lays out what she purportedly said. I don't necessarily know if that's memorialized in text messages, so I don't want you to go down that rabbit hole thinking that, you know, that's all there is to it. Okay.
The question, yeah, that's great. The question, I appreciate it because I'm not privy to that. The question, though, asked was, did you send communication? Send to me would be an email, U.S. mail, or a text message.
Okay.
So anyway, Mr. Kokomo, with the court's permission, if he's available to do it, just play them. They're very short, and then I'd like to answer your questions.
Sure.
Is that okay?
Yes, sir.
Doesn't Keith Adams first. And the record should reflect that there's also some people who write in on this at the bottom. And specifically, I'd like everyone to take note that a person who's very, very well respected on following trials said Keith Adams is a phenomenal lawyer. You will see that on the bottom.
Isn't that self-serving? I just wanted, I mean, I still want to see if I still got it, okay?
Did you discuss with Mr. Anderson that Jeffrey Williams was going to pay for the heroin that Buck had stolen from your apartment?
Objection, Your Honor, that would be hearsay, and there is no exception for it. Overrule or no?
Number one.
Unless, Your Honor, someone is on the list. Prove that up, which there is not.
There is, she cannot.
Yes.
Ms. Love is messy.
I don't know if the court heard it properly in this courtroom, but it's clear Ms. Love said something to the effect of, there is no witness to say anything like that. There's no witness on the witness list.
Yeah, I'll take judicial notice of the official transcript. And if Ms. Weaver will provide the court with that particular part of the transcript for my consideration, even if it's a rough one. Can you play it again for me one more time? I mean, I'll consider it, but I'm gonna take note of what's in the transcript.
Of course.
Okay.
Thank you.
Mr. Kokomo, can you play that again, please? A little louder.
I can get you the date. I have Friday. I'll move on.
Did you discuss with Mr. Anderson that Jeffrey Williams was going to pay for the heroin that Buck had stolen from your apartment?
Objection, Your Honor, that would be hearsay, and there is no exception for it.
Number one.
Unless, Your Honor, someone is on the list to prove that up, which there is not.
There is, she cannot.
Yes.
So by telling the jurors, Your Honor, there is
And so,
no one who can testify to that, whatever the exact words are. That is testifying in front of the jury. Number two is the exchange between Ms. Love and Ms. Bennett concerning what I believe to be text messages. Understanding what the court said is under seal, which I never saw, but the way that the question is framed is, did Ms. Bennett send communication? Do you have that, Mr. Kokomo? Otherwise, I'm going to continue. Do you have it right now?
Yes, I sent that to Mr. Hamilton.
And did you send a communication to anyone in the district attorney's office stating you did not care what the judge said, no one could make you testify, and did you give specific, explicit instructions as to what to tell the judge to do? Objection, cause out question.
No.
I will rule the objection.
Did you tell anyone in the district attorney's office that the judge could kiss your ass?
No. I told Mr. Hamilton to have the judge to call me so I could tell him I'm being harassed. That's exactly what I said.
Your Honor, permission to treat the witness pursuant to Brown.
I'll
So, Your Honor, the way I heard it, the initial part of the question was the same communication to the attorney's office with an explicit whatever message, whatever the words are. So, and target that. To answer your question directly, so those are 2 points that I'd like only Ms. Love can answer. Then Ms. Love talked about on redirect, which was hostile witness cross-examination. Talked about meeting with Ms. Bennett on the bench outside of the courtroom with people nearby. That's how it came out. Ms. Bennett never agreed that there were people nearby. That was Ms. Love saying that. And then it became just communication of what was said there, and Ms. Love somehow made Ms. Bennett feel so uncomfortable Ms. Bennett want to harm herself. So you have that series of questions on the courtroom bench. In addition to that, Ms. Love said, "Isn't it true that I communicated with you via telephone at various times?" This is during the, I'm not sure which day, but I believe it's the second day on who's arrest. And then Ms. Love said, "Isn't it true that I called you to check on you, on how you were doing?" These are quotes from the video. I'm not saying from the court report. "Isn't it true that I told you I wanted you to speak with our victim witness advocate at this office? Isn't it true I asked you about Jeffrey Williams while we were in the Wendy's parking lot? Wendy's parking lot had Investigator Randolph with them. I have no idea what Investigator Randolph heard or knows he took, etc. Isn't it true that I asked you whether Mr. Anderson," said Michael Anderson, "and Jeffrey Williams were friends before Anderson 2013? Isn't it true you never once said that these things did not occur? Isn't it true I came outside, sat down on the bench next to you isn't it true? I asked you how you're doing. Isn't it true? You told me you were beginning to feel like you wanted to harm yourself again. Isn't it true? I asked you what caused you to feel this way. Isn't it true? You told me you miss love. You are the reason I'm starting to feel this way. Isn't it true that I then left your presence? Isn't it true that never once did you tell anyone in the district attorney's office that this incident where you alleged that young thug, excuse me, Thug DK and Thug's brother robbed you did not occur? That includes Miss Love as a witness. She's saying anyone in the district attorney's office. Isn't it true? The only thing we told you had to do was appear, and I can't understand it. Something about a subpoena. Isn't it true that on May 13, 2013, I had never spoken with you in my life? Did I ask you about Donovan Thomas when we met? I believe it's at the Wendy's, Your Honor, so Investigator Randolph would be around that area. I have no idea what you heard. You remember tearing up when I asked you about Donovan Thomas. So did we talk about him getting killed when you and I met? Did you indicate that it was messed up what happened to him? I didn't, nobody did this. Ms. Love injected herself into the proceedings. There's not a waiver here. She just do it on her own. You don't have to sit here and stop her from becoming a witness.
Did you object at the times that she said all these?
There's no objection.
By any of you? No. But don't you have to object, preserve the, or let the court know at that point in time? That's one of the issues that the state's raised, is that you all failed to timely object.
The state is wrong. The state is wrong. Respectfully, because this is not an appeal where I didn't ask for her to become a witness. The case that the state cites is the contemporaneous objection rule, and you want to stop the question. Ms. Love decided voluntarily and freely to interject herself in the proceedings. There's no objection.
But no, you still have to
becoming a
object.
witness. No,
I disagree with you. You still have to object as soon as you realize that there's an issue, that to preserve the issue so that the appellate court doesn't kind of take away, right?
but what's the issue?
The issue is what you just told me.
No, the
That she's injecting herself as a witness.
and that's okay.
I mean, that's what your allegation is.
That's okay though.
Okay, but that kind of at least preserves the issue for the court to consider then and make a ruling on it.
The court is considering now, did Ms. Love become a witness in the
Okay,
case?
All right, then the other thing is we haven't completed the examination of Ms. Bennett. So all the conversations, and this is why I asked you to kind of limit as to the conversations that you believe Ms. Love had, and there's no other third party, because you can certainly examine the witness about those particular statements that were allegedly made, or the third party can be examined at some point.
But there, okay, sorry.
I'm sorry. So that's why I asked you. I'm more concerned about those conversations that you claim where it was just Miss Love and the witness, and she is purportedly, as you said, interjected herself into the matter.
So I gave you two pristine examples that cannot go without the jurors understanding it. The first one is, did you send, this is Ms. Love's words, did you send a communication to anyone in district attorney's office stating you did not care what the judge said, no one could make you testify, and did you give explicit instructions as to what to tell the judge to do? That is a question. The answer is no. The answer is no. Ms. Bennett said no. So there's nobody else in this planet that I can go to ask, why did Ms. Love say that? In addition, saying to the Honorable Keith Adams' question, there's no witness who's going to come in and testify to that. There's no witness on the witness list. Ms. Love, that's Ms. Love's statement in front of the jury. She has no right. That is a witness.
But what about the when the case law indicates, and you all know this, that statements of counsel are not to be considered as evidence.
But that you cannot do that. When Ms. Love, that's not an objection. That is a statement to influence the jury. There is no witness.
I think a few of you have done that during this trial. And that is just something that it's a practice that is not permitted. It's really not condoned at all, but that you're really not supposed to comment in front of a jury improperly.
Judge, Miss Love put her own credibility in front of this jury. There is no way to erase it. There's no limiting instructions.
But I'm going to charge the jury at the end of this case that statements of counsel, opening statements, closing arguments, the questions asked by counsel are not to be considered as evidence. They're not.
But Mr. Williams has the right to cross-examine.
I do. You do. And that's why I'm asking you about the times that she has.
I gave them to you.
Okay. So
I gave you all those times about telephone conversations. There were just the two of them.
So you're saying the two areas that I'll take judicial notice of, as well as anything that's been on the transcript, and that was on the 25th of March?
Not that I believe. I think it was the 29th, 28th and 29th of March.
28, 29 March. I'll consider those. And then the other ones you point out for consideration of the communications, but on the bench outside the courtroom. Is that correct?
Bench outside the courtroom. And then how do you get around the text message when it's not supported by the text message?
What text message? Which ones are you talking about?
When Ms. Love specifically said, and did you send a communication to anyone in the district attorney's office stating that you did not care what the judge said, no one can make you testify, and did you give an explicit instructions as to what you tell the judge to do?
What court, what exhibit was that, or trial exhibit was that was introduced? We need to refer for it to record.
That's fine. That's going to be in all the text messages. I don't know what the state called it, but the question.
Let me just pause a second.
Sure.
Mr. Helsky or Ms. Weaver, do you know what court exhibit or what exhibit that was? But I need to reference it for the record anyway, so. All right, just give me 1 second, please. Mr. Steele, I'm have in front of me states 33 alpha alpha states 34 alpha alpha and states 35 alpha alpha. If you want to take a look at them and tell me exactly where it is that, in either one of those three, also have 32 alpha and alpha alpha. Let me take a look at that right quick as you're looking at that. There's also states 32 alpha alpha, which is the purports to be the text messages from Miss Bennett's son. His phone. Yes, you can, sir.
This is on 34A.
34 alpha alpha.
Giving them all back.
All right, thank you. Okay, all right.
And the statement made by Miss Love that I've,
Okay, and 34 alpha, 34 alpha alpha.
right, that is the closest you're going to get to
Which statement are you referring to in this
Okay.
exhibit?
Miss Love, the one I handed to you, but Miss Love stated in front of the jury, she testified. And did you send a communication to anyone in the district attorney's office stating you did not care what the judge said? No one could make you testify and did you give explicit instructions as to what to tell the judge to do? And in the document I just get.
34 alpha alpha.
That is not even close to a fair summary of what is written by Miss Bennett. And Miss Bennett specifically said, no, that is not what I said. And the only person who can be challenged on that testimony, because that's what it was, is Miss Love. And the state's case that they cited to you, which is Bonner, B-O-N-N-E-R versus State, 192 Georgia Appeal, 721 1989 case. And the state said that this is the only case in Georgia on point. I don't agree with that, but that's what they wrote. And in Bonner, it actually helps Mr. Williams, because in Bonner, what happened was the prosecutor.
What's the citation for Bonner again?
Your Honor, it's 192 Georgia Appeal, 721 386 Southeast 2D 379 1989.
192 Georgia Appeal, what? I'm sorry,
721. It's a short opinion. It's in Division 3.
Okay, Bonner, which is, as you indicated, 192 Georgia Appeal 721.
So I find this case to be fabulous for Mr. Williams. In Division 3, the court wrote that the transcript reveals, in regard to appellant's final enumeration, that after appellant testified on direct examination that she had not visited the victim's bedroom, the district attorney cross-examined appellant about a statement she had made to the district attorney himself prior to trial. The district attorney called to appellant's mind the time, place, and circumstances surrounding the conversation, in which appellant was asked whether she told the district attorney that she went back into the victim's bedroom to listen to the radio. Now I'm skipping, Your Honor, to the end of the opinion.
Well, I don't want you to skip, Brent. I want you to kind of also take a look at what there's an objection that was interposed on an unsworn witness.
Yeah, But I'm saying
Okay,
that
so-
she needs to testify. I don't care that she became a witness. I
But
want to cross
that
her now.
preserved the issue for appellate review and for the court to kind of take it up. That's one of the things the state's saying that you should have done at that point in
No,
time. But
I don't.
we'll
Okay.
continue with it. But
All right.
anyways, but yes.
Keep reading, or can I go
No,
to?
go ahead. Yeah.
So if you go to the very end of the opinion, I don't know how many lines because we're not looking at the same,
Yes, sir.
but at the end of the opinion, if you could target, it's maybe, I don't know, 12 lines up. The transcript reveals that the district attorney laid the proper foundation, but rather, and this is what I stress, but rather than denying making the statement, appellant admitted having done so. Thus, contrary to appellant's contention, the transcript established that it was not necessary for the district attorney as the cross-examiner to prove the making of the statement. And accordingly, we find that the failure of the district attorney to be sworn as a witness and to be available for cross-examination by appellant did not constitute reversible error. Here, Ms. Bennett denied making that statement. She denies Ms. Love's assertion in her question about give explicit instructions as to what to tell you, and that she did not care what you said. The text message that I gave you, and I didn't count the pages, but it is in that exhibit in blue at the top, is Ms. Bennett saying, I'll explain it to the judge. She was polite about the court. She was not rude. That is something that needs to go to jury for this reason. And this is the important reason. Ms. Bennett is exculpatory to Mr. Williams. This is not like you can strike or you can give an instruction. She is exculpatory. And what Ms. Love did is three witnesses, one lawyer and two witnesses, she decimated their credibility. She's telling the jurors that Ms. Bennett is lawless, doesn't give anything about you. That will bother the jurors. They will discount her. Number two, she tells the jurors that the Honorable Keith Adams' question is made up by Keith Adams. He's not truthful. And third, she has decimated the credibility of the witness who has not yet been called, because she has said there is no witness who is on the witness list who will testify to that. So when the witness does come in and testify to it, the jurors are already clued in, that is a lie. Miss Love knows exactly what she's doing, and she is testifying from the jury, and we have questions for her. And the questions are simple.
All right, let's focus, because the focus is on, remember, statements of counsel are not to be considered as evidence anyways, but focus on the issue of Miss Love and the statements that she purportedly has made to Miss Bennett that you can't examine. How come you can't examine Miss Bennett on the stand about those statements and utilize the text messages?
Because I would say to Miss Bennett, what did Miss Love mean when she said, did you send a communication to anyone in the district attorney's office stating that you do not care what the judge said and no one could make you testify and did you give an explicit instruction as to what to tell the judge to do? And the answer is going to be, I have no idea what Miss Love was thinking. I don't know why she asked me that question. I already told you that's not true. So you have to ask Miss Love, why would you say that? Why did you put in the jurors' minds that this witness is under the law, that she curses at the judge, that the judge can kiss her
ass?
Well, I don't want to say it,
Well,
but
here's the thing as well. If that's what you're looking to get at to impeach her, to get her, I think there's another methodology of doing that.
I don't believe I know that methodology.
No, I'm telling you that I told you that there may be a exhibit that, like I said, they have a material witness warrant, and for good cause, I'd be willing to unseal it and you can look at it.
I'll look at it.
And that may, I'm telling you from the court's perspective, that if you're, because if you're attempting to have Miss Love explain this, even though counsel shouldn't inject themselves as a witness, I understand that, but I do believe that there is some that this references conversations that are in an affidavit that you may be able to use to to further examine the witness.
That is not comport with the question. That is a quote. And I know we go by court reporter, but that is the quote online from the trial. In addition to that, you know.
Okay, well, flush out did you send the communication?
Right. That is not the spoken word. Send a communication is email, a letter, text message.
So what did Ms. Bennett say about that?
And that goes to the Bishop case. She said no. And the Bishop case said, well, she would have said yes, then what's the point of cross-examination? And Your Honor, I hear what you said, and I respect it. And you said it multiple times. Look, the jurors are going to be told that the lawyer's questions are not evidence. But that would do away with the unsworn witness rule. Every case, I have cases I cited to you from the 2nd Circuit, 3rd Circuit, 7th Circuit, 6th Circuit, 8th Circuit, 9th Circuit, 10th Circuit, 11th Circuit, U.S. Supreme Court, Georgia. Every one of them say the lawyer can't inject their personal knowledge as if they are vouching for it. And that's what Ms. Love did. It doesn't matter that you can tell the jurors that the questions of the lawyers are not to be used as evidence. The answer is that Ms. Love deliberately, intentionally, knowingly, and voluntarily injected herself to make her credibility as a prosecutor. You know, we value prosecutors. We all value prosecutors. They have tremendous power that we bend down to and say, we give you this power. And Ms. Love has wielded that power wrongly. And she has she's not asking questions. She's saying, me, did you tell me? Did you send the communication? Here are all, she's holding text messages while she's doing that. Did you send communication? She is calling this witness, Mr. Adams, and the witness who has not yet been called, that it's not true. And I've never heard an objection except from this prosecutor where they put in evidence. Judge, this will not come into evidence. There's no witness to say that. That is testifying. And it needs to be explained. And I don't know why we're here. This was not my intention. And no, I didn't waive it. And we don't have to sit here. We don't lay in wait. Miss Love was
Bonner
doing
seems
this.
to indicate that that there was an objection made as to the unsworn witness. That's exactly what the basis for the objection was. You didn't make one.
Yeah, but you got to read further in these other cases. I'm asking for Miss Love to become a witness. She enveloped herself. She's intrinsically intertwined for whatever reason in what she did in the case. I understand that she said that other people around her on the bench. Other people around does not mean that they were part of the communication. Other people around doesn't mean they heard everything. The telephone calls that Miss Love had, we don't accept that it was on a speakerphone with someone else there. She's texting the woman on New Year's, telling her what a great mother she is. What a symbol, I'm not quoting now, but a symbol of the community she is. You know, these are inappropriate. And lawyers aren't supposed to make lawyers the object of the trial. Miss Love made herself the object of the trial, tried to cut the knees out for Mr. Adams by saying he has no right to ask that question because there's no witness who will say it. Those are all the wrongs that the ethical code and the case law tell us to do. I'm very aware of your time limit. I know there was issues.
No, I'm gonna let you have a little more time. So,
but
tell me about the Rule 3.7. If there's any other case law that seems to that you want to point to my attention from Georgia, all the other of course states are persuasive. But is there anything else that our Georgia courts have indicated that would make up terms of the unsworn witness? And also, of course, it's discouraged that lawyers are witnesses anyway. So, and unless they're testifying, consistent with the proper circumstances.
Yes, to answer your question, I believe I cited it. Let me just pull it up. It is a case, I believe, that the Honorable Bruce Harvey did. The quote, Bruce Harvey, when cases were cases, 1985.
Is that when we had paper advance sheets?
Yeah.
Okay, all right.
It's actually before my time, but I don't mean that to Mr. Harvey. It's Castell, Castell versus Kemp. Castell versus Kemp. It's 254 Georgia, 556.
So you said 254 Georgia?
556. It's in your package if you
Okay.
care. And it's 331 Southeast 2D, 528. It's 1985. And if you look at the left-hand side of the copy I've given this honorable court in the parties, you will see counsel, the Honorable Bruce Harvey.
Is in this packet of materials you gave me?
Yes, it is. It should be, this case, it should be.
The case I have is Dillon versus Common.
Right after that. You should have the next case, Your Honor.
People versus
You should have, it's a small case, so it may, you know, the staples may have clicked together, but it's Castell, Castell versus Kemp.
do you have it, Wes?
Should be the fifth one.
Yes, sir, you may. All right, sir, I now have Castell versus Kemp.
So on the second page, the left-hand side,
Yes, sir.
the 12th line in the center, the roles of an advocate and of a witness are inconsistent. The function of an advocate is to advance or argue the case of another, while that of a witness is to state facts objectively. And then cites State Bar of Georgia's Code of Responsibility, Ethical Code 5-9, 1983. Furthermore, where the question arises, doubts should be resolved in favor of the lawyer testifying and against his continuing as an advocate. And that again cites to the ethical code. And then on the right-hand side, the second full paragraph, the rules of the Code of Professional Responsibility do have the effect of law. Although only couched in aspirational terms, these rules cannot be ignored if we are to maintain integrity and credibility of our judicial process. So I believe that that shows that the ethical code is in play here when a prosecutor does what Prosecutor Love did. And it's worse when it's a prosecutor. All these cases I cited to the court, they all say when you're talking about a prosecutor becoming a witness, it is triggering rights of the accused, as opposed to other lawyers where you might just say what the lawyer says is not evidence. Here, the prosecutor has to be looking out for the rights of everybody. That's why there's Brady obligations. And in this case, Ms. Love just went way over the top and injected herself. Your Honor, the United States versus Hosford, Hosford, which should be the first case, again, this honorable court in the parties, which is 782F2D 936. It's 11th Circuit, 1986. In that case, the AUSA, his name is McGee, MC capital GED, did not formally appear as a witness, but he was cross-examined. And I mean, he was doing cross-examination and he was involved in the facts of the case like Ms. Love. And on page 3 of 5, the 11th Circuit goes through a 4-part analysis, but on the right-hand side, the 7th line in the center, specifically, I think this applies. The 11th Circuit said that third, the performance of the dual roles by a prosecutor might create confusion on the part of the trier of fact as to whether the prosecutor is speaking in the capacity of an advocate or of a witness, thus raising the possibility of the trier of fact, the trier according testimonial credit to the prosecutor's closing argument. And here, that's what we have. We have the cross-examination or the redirect examination or the direct examination of a, quote, hostile witness, where Ms. Love is, through her questionings, raising the possibility that the jury will think that they're giving testimonial credit to what she's saying. You can't ignore that, and you can't erase it. The 4th one, right after that, the 11th Circuit wrote, fourth, the rule reflects a broader concern for public confidence in the administration of justice and implements the maxim that justice must satisfy the appearance of justice. This concern is especially significant where the testifying attorney represents the prosecuting arm of a federal government. And I don't know how we got here. I don't know why the state thinks that this is no big deal, just cross-examine someone else. This is exactly what we don't do. It's an ethical violation. It is a lawful, legal violation. And I ask this honorable court to disqualify Ms. Love from going forward in our case. She will be a witness in the case. And we will ask her, we'll telegraph her what concerns we have. Why did she, I told you, what did she do at the bench to make what did she do?
Outside bench, that conversation that was had purportedly outside.
Right, what Ms. Love reported to us. That one where others were around, that's how it was said, others were around, not others were participants. The telephone calls, the announcement in front of the jury, it's not an objection to say there is no witness who will say what Mr. Adams said, that this was a theft and Jeffrey Williams repaid the theft. And did you send, Ms. Bennett, did you send communication that the judge, I'm not going to go through it again, but inappropriate things towards this court? And the answer was no. So that's why Bonner, I believe, it's helpful.
All right.
No, thank you, Your Honor. Thank you very much.
Okay. All right. Ms. Uhalski?
And by the way, can I say one other thing? Do you mind if I just say one other thing? Your Honor,
Yes.
I looked at my notes. It is Thursday as well as Friday, not just, I think I said earlier Friday. It is Thursday, some of these concerns. They came up on both direct and redirect.
All right, Mr. Uhalski, go right
Yes,
ahead.
Your Honor.
right.
Let's start with 3.7.
I'm sorry, start with what?
Rule 3.7. The lawyer as witness professional conduct rule. I wanted to point out about Castell and in connection with 3.7, just while it's at the front of mind. Castell was a case where Bruce Harvey tried to argue his own ineffective assistance. That's the conflict that we're cited to when we're talking about Castell. And when we're talking about Rule 3.7, the lawyer as an advocate shouldn't be also a witness. It's true what Mr. Steele says about these rules having binding effect, but there's nothing that says that even if there was a 3.7 violation, which we dispute, of course, that the remedy is disqualification of the prosecutor. The remedy, as far as I remember looking it up just yesterday, was public reprimand if there was a 3.7 violation in the first place.
So that's not for me. That's the collateral offense.
Sure.
The collateral consequence. The legal consequence for the trial would be for they've asked me to consider that she'd be disqualified.
Sure, but I guess the larger point about Castell, going back, is the idea like of an attorney on a habeas to argue that their own performance at trial was ineffective. That's kind of an impossible conflict of interest. So I don't think we have anything resembling that here. And I want to go to the questions that Mr. Steele was getting into, and I'm not going to get too much back into the briefing because I know Your Honor has digested that. But starting with the comment about Mr. Adams's question about Buck or whatever that was. So it's a hearsay objection, and then it was followed up with, hey, there's not going to be a witness on the witness list. That's the attorney.
You'd agree that she shouldn't have said that.
At best, it's a speaking objection. And if the remedy for a speaking objection, Your Honor, is disqualification, guess how many defense attorneys we have left? You see what I'm saying? So at best, it's a speaking objection, and that's improper, but it's not the lawyer testifying. Again, the jury is presumed to follow the judge's instructions. The judge has, in this case, and will continue to advise the jury that what the lawyers say is not evidence. And in that connection, Your Honor, one of the cases, I'm not going to belabor it, but Palmer v. States, and this is on page 4 of the state's brief. It's a Georgia Supreme Court case. It's 236 Georgia 507 at 507 and 508. There they approved of a jury instruction, and I will concede that it was a curative in that case, but it says that the instruction said that anything a prosecutor might say while asking questions on cross-examination was not evidence. So even if you think that was an improper speaking objection, which is not the first one we've seen, the remedy is not disqualification, which, as Your Honor is aware, is a radical remedy. Going forward to this other communication, the second major point that Your Honor had asked us to discuss, this instance where Ms. Love asked Ms. A.B., isn't it true that you sent a communication talking about the judge can kiss your ass? That's just not good phrasing. Send a communication. It doesn't necessarily mean it doesn't say, didn't you send a text? It doesn't say, didn't you send an email? It says, didn't you send a communication? That's just kind of maybe imprecise phrasing. The remedy for imprecise phrasing is not disqualification either. And if you listen to the rest of that question, Ms. Love went on right after that, really kind of interrupting herself, and clarified and said, did you tell anyone at the DA office that the judge could kiss your ass? Did you tell anyone that? So she heard her own imprecision, she corrected it, and then the answer was no. So we had this big argument about how Bonner doesn't apply because in Bonner, the witness said yes. Oh no, well in this case, the witness said no. It's a question.
But how are they going to impeach her on it?
However they want. They can cross-examine her. They have the text, every single text that anybody had with Bennett. Those speak for themselves. They can cross, and the very next witness that I believe the state may call in relation to AB is going to be the investigator who was going to be present for these communications. And just to clarify, which I think wasn't clear, we're not saying, and it's not true that Ms. AB ever sent a text that said the judge can do this. That was an oral statement that was made, and Ms. Love said, hey, didn't you tell me this? And we can ask Ms. AB about it. We can ask the investigator who swore an affidavit to that effect, which Your Honor is aware of. And so there's no unsworn witness violation. And I'm not going to make too much more, fodder of the Rule 3.7 stuff and the idea of like preserving objections, because it's true what Mr. Steele says. That is an appellate doctrine, and if you don't object to it, you waive it. The contemporaneous objection rule says if you don't object by the time the next question comes, you've waived it for appellate review. That plain error and stuff, all that still applies for an appellate matter. I just wanted to point out that the sort of artful practice that you see here is a little bit concerning, especially when you look at the sort of injection that happened with Mr. AB when it comes to lawyers asserting potentially facts not in evidence, becoming part of the evidence. Again, if disqualification were the remedy here for what is alleged, and we're not even conceding that the allegations are true, but if disqualification were the remedy, where's the Georgia case that says that? And if indeed that was the remedy, again, like bye-bye defense lawyers, because Your Honor's been aware, of this going on both sides. We have we have permission to lead a witness. Okay, that's proper under Brown. When you're asking a leading question, it's always going to presuppose some sort of desired response. That's just the textbook way that works. The fact that we have communications with the state's witness prior to that state's witness testimony, and that somehow is being made into a disqualification grounds, that's just prepping a witness. That's just trial practice. You can't avoid that. You're going to have to communicate with your witnesses to get them up on the stand, especially difficult witnesses in high profile cases. So again, what the lawyers say is not evidence. The jury know that, and they're going to be told that, and they're going to follow
What about
that.
okay, let's assume I believe that, or that assertion based on the text messages that at least we're in states 34 alpha. What about the communications with Ms. Love had with Ms. Bennett on the benches outside the courtroom that were not memorialized or witnessed by a third party?
I don't believe that any such communications exist. Ms. Bennett said nobody was nearby. That's her answer, but that's not necessarily what reflects the truth.
You don't believe that's a problem? I mean, how is the defense or anybody else going to test that? Then you are being asked to look at the credibility of lawyer versus witness because you don't have a third party.
Well, that's what Ms. Bennett says, that there's no third party. That doesn't mean we don't have a third party. I mean,
Was there a third party present?
I believe
during all of the conversation?
As a matter of protocol for these conversations, I believe there's going to have to be an investigator or a victim witness advocate. I believe Ms. Lieutenant, I mean, I'm not going to speak to it. I wasn't there, but as a matter of protocol, you get in a lot of trouble if you don't do that. So if we have investigators present when we're dealing with our witnesses, and just because Ms. AB said no, there weren't people nearby. I mean,
Okay, well, I'm just, look, they're asking me for a draconian, remedy,
Sure.
which is,
indeed.
hey, look, she being Miss Love, purportedly had conversations with Miss Bennett and nobody else was present. That's what Miss Bennett seems to have indicated. So are you telling me that, if need be, the defense can cross-examine or has the ability to call, if appropriate, the third parties that may have been present, victim advocate or the investigator?
On information belief, yes, I believe that would be possible.
They were present the entire time? Yeah, of Miss Love's conversation? Other than when she said, we're going to leave. I'm going to leave because you're making me angry.
Other than the, kind of texts about this or that administrative detail, like, Happy New Year or whatever it is, these collateral matters, yeah, I believe there would have had to have been an investigator present for any of these.
Had to have been, or there was? Because I mean, look, if you don't know, you don't know. But I mean, that's kind of Mr. Steele's point. I mean, because if you're going to represent me as an officer of the court, yeah, we had, despite the fact of what you may have said, Judge, we had somebody that was there the entirety of the time, or can refute or rebut that assertion. That's the assertion right now. That's what I kind of want to get some clarity on. So if you want to, just let me know before you commit to that. I know what your assumption is and practice is, but I want to know whether or not she had she being Miss Love had conversations that were witnessed by some particular member of your team that would refute or otherwise not make this an issue, because it's an issue only because there's no way I can test if that truly was a conversation. There's no way as a cross-examiner I can test whether or not that third party witnesses telling me what really happened.
Okay, so I'm
going to hold on that and let you.
I have an update on that.
Okay.
I believe the conversation that we're referring to, I'm being told there was an investigator present. Antonio Long was present for that.
Okay. All right. So if need be, Mr. Long
Sure.
can be, if appropriate, can be examined on that. Okay. All right. What about what about the third group of statements? This communication by telephone at various times between Ms. Love and Ms. Bennett. And I want to say that that is, let's see. And you all might be able to help me out with that. Which one of the state's exhibits, 33, 34, or 35, are the ones that there's the assertions of that Miss Love is having a conversation with Miss Bennett? Can one of y'all tell me?
So the text conversations that have occurred between anybody and Miss Bennett, anyone in the DA with Miss Bennett, those the court has, all the parties have all those.
Those are 33, 34, and 35 alpha.
I believe so.
All right, but I want to know which ones of these conversations are the conversations purportedly that Miss Love had with Miss Bennett? Because some of them are just talking about the son having and getting a job or helping the son get a job. Some of them are just pleasantries of the greetings of the season.
Yeah.
I mean, I'm not concerned about those. I'm more concerned about about anything that may have been said that maybe wasn't witnessed, that might be problematic. That's what I'm trying to look at this time.
Well, I mean, from my understanding, the text messages largely occur between Lieutenant Hamilton and either Miss AB through her son's phone or her direct phone. Again, when you're talking about conversations about, coming to court, just pleasantries and stuff like that, I'm not aware of any conversation that happened that was of substance that wouldn't have been witnessed by an investigator or some other advocate per protocol. I mean, I'm not the universe of all the potential things that could have been said. I mean, I'm not really in a position to represent like what may or may not have happened over the phone, but there's not going to be anything substantial as far as any oral statements that wouldn't be covered by this investigative protocol. And again, these texts, they've been turned over. They speak for themselves. This AB can be cross-examined on any of this stuff, including the oral statements. I understand the court's
kind of shifted on to you, Mr. Yowski, and your team in regards to, because Mr. Steele has said, okay, listen, that's why, maybe what I need to do is I need to let you all take a look at 33, 34, and 35 alpha and parse out for me, because as they were sent to all councils a couple days ago, some were conversations had with two of your investigators, one of them being Chief Investigator Long. The other one was with, I want to say, Investigator Hamilton. And then the other one was reportedly with Miss Love. So there's 3 sets, I think, of text messages. That's kind of what I need you to kind of look at. I need you to look at this last set of communication at various times of who within those particular exhibits had text message conversations. What I'm focusing upon at this point in time is of course, Miss Love. So let me just recess about 10 minutes and let you all kind of look at that. That's kind of what I want to address. I just want to make sure that I've gotten it correct. Okay.
That's fine.
Okay. All right. So we're going to be in recess 10 minutes. All right. Can we ask somebody to come back in, please? Excuse me. All right, thank you, Sergeant. All right. Mr. Uhalski, we'll be able to parse out as it pertains to the state's exhibits.
All right, I was able to get some clarity on the two issues we left off on, starting with, I can emphatically state in my place that Ms. Love was never alone with Ms. Bennett for any oral conversations. With
As
respect
pertains to the bench conversation.
Yes.
Outside courtroom bench conversation.
Yes, and that one, and I'll clarify that it started out with Ms. Love and Antonio Long, and then there was this representation from AB about harming herself due to the fact that the state wants her to testify. By the way, but after that point, Adrian was sort of backed off, and then Tamika Kelly and Partrina Baker then went ahead and got with Miss AB at that time. And I will say, if Your Honor thinks that cross-examining AB on that conversation is
You're
not
talking about
enough.
Ms. Bennett.
Yes, sir.
Okay, all right.
If Your Honor thinks that the defense cross-examining AB on that conversation and the circumstances surrounding it and everything about it is somehow not enough under the Constitution, then you have those additional witnesses. The next part is the text message conversations, okay? I wouldn't even call them conversations, but they're
Okay,
contained.
let's the first, Grant, tell me which text message conversations, because I want to say there's 32, 33, and 34 alpha. Is that correct?
Yeah, 35 alpha
Oh, and
alpha.
35, is it started at 33 or 32? You all have them, so I don't, so.
Well, the ones that pertain to Ms. Love's conversations, the text communications are 35 alpha alpha.
Okay, so let's take a look at those.
And so when you do take a look at those, and I'm looking at them now, I'll just characterize them. They're sort of pleasantries. How are you doing? Good morning, et cetera. I mean, we can take a look at every word of them. And like I said, they speak for themselves.
And
And
let me
again,
take a look at 35
sir.
alpha.
and the approach.
Yes, you may. Thank you.
I'll give Your Honor some time to look at those, but I'll be ready to continue at the court's pleasure.
Okay, all right.
So what I would say about those text messages, Your Honor, as you look at them, they're pleasantries, they're administrative, they're collateral. And the larger point, one of the larger points is that these are just text messages that Ms. Love sent to AB as part of, we want you to testify, we're, using you in the case. For the most part, AB doesn't really say anything except for those two instances, and those are administrative responses in the first place. And even more than that, the idea that a prosecutor texting a witness about coming in to testify and how are you doing and all this other stuff, that's just text messages that occur between Ms. Love and AB. That's not unsworn testimony. And when it comes to the ability of the defense and the right of the defense to impeach on matters like that, Your Honor, I want to point you emphatically to Scott v. State. Okay, that's a 2020 Georgia Supreme Court decision, 309 Georgia 764, and again that's 309 Georgia 764 at 770, and it says as follows. Under OCGA 24-6-621, a witness may be impeached by disproving the facts testified to by the witness. But this statutory provision does not provide a party with an unlimited ability to impeach a witness by contradiction. To use an example of something that did come out maybe in testimony, isn't it true you were late to the meeting? Okay, yes, no, it doesn't matter what the answer is, it's collateral. Scott says, a party may not use extrinsic evidence to impeach a witness by contradiction on a matter collateral to the material issues at trial. Whether AB was late to the meeting, not material to the trial. It goes on to say that even under the former rule that preceded 621, a witness may not be impeached based upon a discrepancy relating to a wholly immaterial matter. And even further in Scott, going on to 771, it talks about how the person's, the ability to disprove something that's relevant to credibility, that a discrepancy on that point does not relate to a material issue in the case. So I'm going to leave the court with Scott. I'm going to leave the court with my understanding of the extent of the text communications that would have just been between AB and Ms. Love. But I want to leave the court with the final impression, again, reiterating that those text messages are not testimony. And really, if the defense wants to talk about them, they could ask Ms. Bennett. And so we would ask the court to deny this motion.
All right. One more thing. Do you all have a copy of the affidavit for the material witness warrant? I'd have to do an order unsealing it.
We can certainly
Do you have a
provide that.
copy of it with you, or do you have, can you get me a copy as I collect
We'll
my
provide
thoughts?
a copy to the court immediately.
Can you all get me one in the next 5 minutes?
Yes,
Okay.
we're working on it now.
All right. Okay. All right. So I want to take a look at it,
Yes, sir.
and I may, depending upon what it says, make some other additional findings. Okay.
All right, thank you, Your Honor.
So I'm just going to recess in place. Per sec, please. It's too loud. Why don't you come to the podium?
Yeah.
Thank you.
I believe this is what the court's going to do, but we just wanted to make sure that we redact and make sure that it doesn't come out to the public, any of this biographical information, date of birth, address, stuff like that, if that makes sense.
I think that could be arranged.
Sure.
Mr. Steele, what I'm going to do is I'll redact out the biographical data of the witness.
No opposition.
Okay.
Okay,
All right.
thank you.
All right, so we'll just do that before when I unseal it. Okay.
Thank you, Your Honor.
Okay. All right. Christina, can I see 34 and 30? Yeah. in a position to give you my thoughts on ruling on this particular issue. The court has considered the issues framed in the defendant Williams' motion to enforce the disqualification of Prosecutor Love. And to that end, I've considered what has been pled in Mr. Williams' motion. I've also considered the state's response to defendant Jeffrey Williams' April 1st, 2024 motion to disqualify. I've also considered the arguments of counsel. I've also taken into account and will take judicial notice of the proceedings to include the transcript of proceedings on, and in particular, 28 and 29 March of 2024. And the court also has had the opportunity to review and consider the following exhibits. States 32 alpha alpha, states 33 alpha alpha, states 34 alpha alpha, and states 35 alpha alpha. In considering these motions, the court has also considered the defense's three groupings of the examination of Ms. Bennett as it pertains to their assertion that Ms. Love has inserted herself and become an unofficial witness. In regards to this, I have also considered and will consider for purposes of the motion the statements that were made in court on the 28th and 29th of March, even though video was shown to the court. In regards to those, the official transcript will be the record that the court considers. I've also considered the communications between Ms. Bennett, the witness, and purported to be Ms. Love and other members of the staff of the district attorney's office. And then third group of consideration is by telephone various times between Ms. Love and Ms. Bennett in states 35 alpha alpha. In considering those, the court has also taken a look at the cases that both the state as well as the defense has proffered and invited the court's attention in respect to this issue of Ms. Love and being an unofficial witness. The court has of note considered Bonner as well as, and Bonner's at 192, Georgia Appeals 721. And also the court has also considered Cantwell versus Kent, 254 Georgia at 556, and Scott as the state 301 Georgia at 764 and 24-6-621, as well as the Georgia Rules of Professional Responsibility. Uh, 3.7. To the defense's arguments and assertion in the first grouping that has been brought to the court's attention on March the 28th and March the 29th of 2024, the court has heard some concerns from Mr. Steele saying that those conversations could not be challenged by any other examination than Ms. Love, and has thus asked the court to disqualify her. The court has considered that particular request, and in regards to the colloquy that is had between Ms. Love and Ms. Bennett, as referenced from the transcript, in the interest of fairness and judicial economy and clarity, the court will unseal the affidavit as it pertains to the material witness warrant that the state sought to comply with to help to facilitate Ms. Bennett's complying with being here as a witness. I will make that available immediately. I will do two things. I will sign an order unsealing that particular affidavit. I will also block out the proprietary information as it relates to Ms. Bennett from that. But Mr. Steele, Mr. Uhalski, I will make the balance of the affidavit in its entirety available. And I believe that that will also provide you with information as to others that may satisfy your concerns in respect to that issue. The second area of communications from the courtroom bench outside the courtroom as it pertains to Ms. Love. I believe that Uhalski is offered and stayed in his place, that Chief Investigator Long would be the person, as well as the two victim advocates that can provide information in respect to any communications that may need to be tested or heard of during that particular period as it relates to that issue. And then thirdly, the communications by telephone at various times in states 35 Alpha Alpha as it relates to Ms. Love and the witness, Ms. Bennett. The court in reviewing those doesn't find anything that would be other than the one advocate's attempts to seek scheduling and pleasantries with the witness. And for those reasons and applying Bonner and the other cases that the court has cited for purposes of this analysis, I'm going to deny the defense's motion to disqualify Ms. Love. I will also, though, as a caveat to all counsel, just invite you all to just be mindful of witness interviews and the importance of third parties being present for the reasons that our professional code of responsibility tells us, so we don't inadvertently make ourselves as lawyer as witness. So with that, that's the court's ruling. Mr. Uhalski, if you will prepare a suitable order for the court's consideration, send that to Mr. Steele. And if I could get that by next Friday, that would be the 12th of April. That would be fabulous. Okay? All right.
Your Honor,
Yes, Mr. Sharp.
as Mr. Steele, I believe, was the only signatory of the motion and did the arguing. I just want to ensure for the record that the Harvey rule is still in effect.
Applies to all. So,
Thank you.
yes. Okay. All right. One other thing, Wes. Okay, all right. I don't think I have anything else I need to add or with you all, other than we'll be back in session at 8:45 on Monday morning. I'll cover with you all my administrative order and just to make sure it'll be entered and all of you will get a copy of it. Okay, anything else? Mr. Harvey?
If one logistical matter, if we are to be here pursuant to your 8:45 requests, we need a current order to get us in before 8:30 so we can be here, be ready to go per your 8:45 requirements. If your staff can prepare us an order allowing us to get in before 8:30, we would appreciate it.
Mr. Harvey, I will take care of that momentarily, okay? All right? Okay. Anything else? All right, if not, I'll see you all for 8:45 on Monday morning, the 8th, and our jurors will be present and we'll take up that, because I believe I told them to be here for 9 o'clock. So we'll, whenever they all get here, that'll give us some time to cover any other administrator that we have to cover. All right, I noticed you all have, Ms. Love has turned it over to you all from the evidence that she and the state are wishing to proceed with, consistent with my orders. So unless there's anything else, I'll see you all on Monday, okay? All right, we're in recess.